Welcome to this channel. Today we are going to explore regulations and procedures for public meetings in India. Before we go into the video, please subscribe this channel and press bell button to get notifications of upcoming videos. Now we go into the video. The regulations and procedures for public meetings in India are available in various laws and rules, including number 1, the Code of Criminal Procedure 1973 CRPC, Section 129 to 132 deal with unlawful assemblies and the power of the magistrate and police to disperse such assemblies. Number 2, the Indian Penal Code 1860 IPC, Section 141 to 145 and 151 to 160 deal with unlawful assemblies, rioting and affray. Number 3, the Police Act 1861. Section 23 and 30 deal with the duties of police officers, including maintaining public order and safety. Number 4, the Representation of the People Act 1951. Sections 123 to 125 deal with election-related offences, including those related to public meetings and processions. Number 5, state-specific laws and rules. Various states have their own laws and rules governing public meetings and processions. These regulations are also reflected in various court judgments and guidelines issued by the Election Commission of India and state governments. Some specific rules that may be relevant include the Model Code of Conduct, guidelines for political parties and candidates during elections, state police standing orders, guidelines for police officers on maintaining law and order, including public meetings and processions, the right to form associations, including political parties, is a fundamental right under Article 19(1)(c) of the Constitution of India. However, the specific procedures and regulations for registering and operating a political party are governed by the Representation of the People Act 1951 and the Election Symbols Reservation of and Allotment Order 1968 issued by the Election Commission of India. To start a political party in India, the following conditions must be met. The party must have a constitution or rules that outline its objectives, structure, and functioning. The party's name and symbols should not be identical or similar to any existing party or symbol. The party should not promote or propagate any ideology that is violative of the Constitution or promotes communication, corruption, or violence. The party needs to register itself with the Election Commission of India to be recognized as a political party. The Election Commission of India (ECI) is the authority responsible for registering and recognizing political parties. The ECI has the power to grant recognition to political parties under the Representation of the People Act 1951 and the Election Symbols Reservation and Allotment Order 1968. To start and run a political party in India, the following procedures and conditions apply. Registration with the Election Commission of India. The party needs to submit its constitution, rules, and other documents to the ECI for registration. Compliance with the Representation of the People Act 1951. The party must comply with the provisions of the Act, including those related to election expenses, donations, and disclosures. Adherence to the Model Code of Conduct. Political parties are expected to adhere to the Model Code of Conduct, which outlines the do's and don'ts during elections. After starting a party, the following steps can be taken. Register the party with the Election Commission of India to gain recognition and access to electoral benefits. Build a strong organizational structure, including a national or state level executive committee. Develop a clear ideology, manifesto, and policies that align with the party's objectives. Engage with the public through meetings, rallies, and social media to build support and promote the party's agenda. Number 6. The rules for conducting meetings within a political party are typically governed by the party's contribution or rules. These may include the party's constitution or rules. These may include notice period for meetings, quorum requirements, voting procedures, roles and responsibilities of office bearers. The rules for conducting public meetings are governed by various laws and regulations, including the Code of Criminal Procedure 1973. The law empowers the police to regulate public meetings and processions to maintain public order. The Representation of the People Act 1951. This act prohibits certain types of speeches or actions that may incite hatred or violence during elections. Model Code of Conduct. Political parties are expected to adhere to the Model Code of Conduct, which outlines the do's and don'ts during elections, including guidelines for public meetings. These are some of the key rules and regulations that govern the functioning of political parties in India. It's essential to consult the relevant laws and regulations for more detailed information. The permission to conduct a public meeting by a political party is typically granted by the local authorities such as the district magistrate or collector, the superintendent of police or commissioner of police, the municipal corporation or local body. The specific authority responsible for granting permission may vary depending on the location and the nature of the meeting. When granting permission for a public meeting, the authority must ensure that the meeting does not pose a threat to public order, peace, or security. The meeting does not violate any provisions of the law or court orders. The party has obtained necessary permissions and clearances from the relevant authorities. The meeting does not cause undue disturbance or obstruction to the general public. The authority may also impose conditions on the party, such as restricting the meeting to a specific area or venue, regulating the number of participants or attendees, ensuring adequate security arrangements are in place. The authority responsible for granting permission has the following duties and responsibilities before the meeting: assessing potential security risks and taking necessary measures, ensuring compliance with relevant laws and regulations, during the meeting, maintaining law and order, ensuring public safety, preventing any unlawful activities or disruptions. After the meeting, ensuring that the venue is restored to its original state, taking action against any violations or lawbreakers. The party organizing the public meeting has the following duties and responsibilities. Prior to the meeting, obtaining necessary permission and clearances, ensuring compliance with relevant laws and regulations, taking necessary measures to maintain law and order. During the meeting, ensuring that the meeting is conducted peacefully and lawfully, preventing any unlawful activities or disruptions, cooperating with law enforcement and agencies. After the meeting, ensuring that the venue is restricted to its original state, reporting any incidents or issues to the authorities. The public participating in the meeting has the following duties and responsibilities: to follow the rules and regulations set by the authorities, to behave peacefully and lawfully, to respect the rights of others, including those with differing opinions, to cooperate with law enforcement agencies, to refrain from engaging in any unlawful activities or disruptions. By participating in the meeting, the public acknowledge their responsibility to maintain law and order and to respect the rights of others. In case of breaches of the regulations governing the public meetings, the following actions can be taken. Action to be taken and who has to take them: law enforcement agencies, police. Take immediate action to restore law and order, prevent further breaches or apprehend those responsible for the breach. Magistrates issue orders to disperse the meeting, impose curfew, or take other necessary measures to maintain public order. Authorities, district administration, take action against the organizers or participants for violating the conditions of permission or breaching the law. Local bodies, take action to restore the venue to the original state and recover costs from the organizers if necessary. Legal action, filing of FIRs, first information reports, against those responsible for the breach. Prosecution under relevant laws such as the Indian Penal Code (IPC) for offences like rioting, assault, or damage to the property. Action under the Representation of the People Act 1951 for election related offences. The specific actions taken will depend on the name and severity of the breaching, and the authorities responsible for enforcing the law will take the necessary steps to address the situation. If the concerned authorities fail to take action in case of violations of the regulations governing public meetings, the following options are available. Higher authorities, superior officers or higher authorities in the chain of command can take action against the delinquent authorities for the failures to act. For example, the district magistrate's superior officer can take action against them for failing to maintain law and order. Judicial interventions. The High Court or the Supreme Court can be approached through a writ petition under Article 226 of Article 32 of the Constitution, respectively. The court can direct the authorities to take action, impose penalties, or even take contempt action against the authorities for failing to comply with their duties. Oversight bodies. Bodies like the State Human Rights Commission, State Election Commission, or the Central Election Commission can be approached for redressal. Those bodies can investigate the matter, recommend action, and monitor the implementation of their recommendations. Public interest litigation, PIL. A PIL can be filed in the High Court or the Supreme Court, highlighting the failure of the authorities to take action. The court can take suo motu cognizance of the matter or entertain a petition from a public spirited individual or organization. The action that can be taken against the delinquent authorities include departmental actions. Disciplinary proceedings can be initiated against the authorities for their failures to act. Penalties such as censure, suspension, or dismissal can be imposed. Criminal action. In case where the failure to act amounts to a criminal offense, such as dereliction of duty or corruption, or criminal proceedings can be initiated. The authorities can be prosecuted under the relevant laws, and if found guilty, they can face imprisonment or fines. The specific actions taken will depend on the circumstances of the case and the applicable laws and regulations. The actions that can be taken against the public who do not follow the regulations governing the public meetings include warning or caution, Law enforcement agencies can issue a warning or caution to individuals who are violating the regulations. Detention or arrest. Individuals who refuse to comply with the regulations or engage in violent or unlawful behavior can be detained or arrested. Prosecutions. Individuals who violate the regulations can be prosecuted under the relevant laws such as Indian Penal Code (IPC) or the Code of Criminal Procedure (CRPC), fine or penalty. Individuals who violate the regulations can be fined or penalized. The following authorities can take action against the public who do not follow the regulations. Police. The police are responsible for maintaining law and order during public meetings. They can take action against individuals who violate the regulations, including detaining or arresting them. Magistrates. Magistrates have the authority to issue orders to disperse unlawful assemblies or impose curfew. They can also direct the police to take action against individuals who violate the regulations. Law enforcement agencies. Law enforcement agencies such as the police can take action against individuals who violate the regulations. The actions can be taken in the following manner. On the spot action. Law enforcement agencies can take immediate action such as detaining or arresting individuals during the public meeting. Filing of FIRs. Law enforcement agency can file FIRs against individuals who violate the regulations, which can lead to prosecution. Investigation and prosecution. Law enforcement officers can investigate the incident and gather evidence which can be used to prosecute individuals who violated the regulations. The specific actions taken will depend on the circumstances of the case and the applicable laws and regulations. If the authorities fail to take action, the government can take the following steps. Departmental action. Initiate disciplinary proceedings against the delinquent authorities, impose penalties such as censure, suspension or dismissal. Transfer or removal. Transfer or remove the authorities who have failed to perform their duties. Investigation. Order an investigation into the matter to determine the cause of the failure and identify those responsible. Corrective action. Take corrective action to address the issues that led to the failure. The authorities in the government who can take action against failures by other authorities include Chief Secretary. The Chief Secretary is the highest making administrative officer in the state and can take disciplinary action against delinquent authorities. Home Secretary. The Home Secretary is responsible for law and order and can take action against authorities who fail to maintain law and order. Chief Minister. The Chief Minister is the head of the government and can take action against authorities who fail to perform their duties. Minister in charge. The minister in charge of the department concerned can take action against authorities who fail to perform their duties. Head of department. The head of department can take disciplinary actions against the subordinate authorities who fail to perform their duties. These authorities can take action based on reports from various agencies, including Vigilance and the Anti-Corruption Bureau, can investigate corruption and misconduct by authorities. Lok Ayukta can investigate complaints against authorities and recommend action. Internal vigilance mechanisms. The departments and organizations can have internal vigilance mechanisms to monitor and report on the performance of their authorities. The specific authorities and procedures may vary depending on the government department or organization concerned. No public meetings, including political rallies or gatherings, are generally not permitted to be held on national highways and other highways. Here is why. Safety and security. Highways are meant for the free flow of traffic, and holding public meetings on them on this can pose safety risks to both the participants and other road users. Traffic congestion. Public meetings on highways can cause significant traffic congestion, leading to inconvenience to commuters and potential disruption to essential services. Section 126 of the Motor Vehicles Act 1988. This section prohibits any construction or obstruction on highways that may interfere with the safety or free flow of traffic. The police authorities, in exercise of their powers under the Code of Criminal Procedure (CRPC) and the Motor Vehicles Act, can prohibit or regulate public meetings on highways to maintain public order and safety. If a public meeting or rally is proposed to be held on a highway, the organizers would typically be required to obtain permission from the relevant authorities, and the authorities would assess the potential impact on traffic and public safety before granting or denying permission. In general, public meetings and rallies are usually held in designated public spaces such as parks, grounds, or auditoriums, which are designed to accommodate large gatherings safely. The necessity for police permission for holding a meeting in a designated public space can vary depending on the specific laws and regulations in place. Here is a general breakdown. In many cases, the local municipal corporation or municipal authority is responsible for managing public spaces. Organizers may need to obtain permission or a permit from the local authority to use the space for a meeting or event. While police permission might not always be required for permission to hold a meeting in a designated public space, the police do have a role in maintaining law and order. If the meeting is likely to cause a disturbance or breach of peace, the police can take action under the relevant laws. It is best to check with the local authority and police department for specific requirements and regulations regarding public meetings and designated spaces as at present. They can provide detailed guidance on the necessary permissions and procedures. Thank you for seeing this video. Please subscribe this channel and press bell button to get notifications of upcoming videos. Thank you.